This is in the International Humanitarian Law Dialogues, which will be discussing the laws of war, past, present, and future. This does not happen without the sponsorship, the encouragement of a variety of organizations, and I'd like to recognize them now. The American Society of International Law with Rick LaRue and Betsy Anderson. The Planned Hood Foundation with Don Ferencz. CHAUTAUQUA Institution, the wonderful location of which we are at today. Washington University School of Law, the Whitney R. Harris Institute, Laila Sadat, we thank you. Syracuse University School of Law, and the man who really was the impetus behind all of this, and hopefully he'll talk about it a little bit later, David Crane. And of course, I'm here on behalf of the Robert H. Jackson Center. This is an extraordinary day, and I couldn't be happier that we were able to obtain the current and past prosecutors from throughout the world. And I must tell you on behalf of the Jackson Center, and most importantly, Jackie Shannon, I wish she was here so all of you could see the person behind all the various phone calls that brought you here from points all around the world for this event today. But it's thrilling. And the organizing committee is just thrilled to have here in the first couple rows those people who represent the international criminal tribunals from throughout the world for this really historic gathering. In order to kick us off, I'd like to introduce Professor John Q. Barrett. Professor Barrett is a professor of law at St. John's University in New York City and the Elizabeth S. Lene Fellow at the Robert H. Jackson Center in Jamestown. He's a graduate of Georgetown University and Harvard Law School and served as a law clerk for Judge A. Leon Higginbotham. For our purposes today, Professor Barrett is writing a biography of the late U.S. Supreme Court Justice and Nuremberg, American Chief Prosecutor at the Nuremberg trials, Robert H. Jackson. For reflections on how the future looked from Nuremberg, mid-20th century visions of humanitarian law and prosecutions of its violators, I present Professor John Barrett.
Thank you, Greg, and the Jackson Center and all of the co-sponsors. It is truly an honor to get to speak to so many people who are and have in their lives devoted themselves to such important work. My topic is looking forward from the Nuremberg moment, the middle of the 20th century, but really my topic is to and from Nuremberg, a 100+ year process of looking forward to international humanitarian law. And what I'm going to do is take you in a summary fashion through a number of points in time to set the stage for the work that these prosecutors have done and the discussions that we will have today. The first, as a backdrop, and this is utterly summary, is the 18th and 19th centuries, where we have a starting point, and it goes obviously back vastly before that, where international relations is based in sovereign governments' rights to wage war and to oppress and abuse internal populations. And the record of the millennia thus constituted a bloody mass with plenty of both, war and violations of human rights. Against that backdrop, at the very end of the 19th century, comes the First Hague Conference in 1899. 26 nations gather, and they reach modest agreements about rules of conduct in war between sovereign nations. And they create an embryonic international court to arbitrate disputes among nations. For our purposes, for Nuremberg purposes, for international law purposes, that moment at the end of the 19th century is a starting point in this span of 100+ years. The second period I'd like to take you to is literally 100 years ago, the year 1907. The United States had previously called, President Theodore Roosevelt had called, for a second Hague Conference. Its principal objective from the United States perspective as the convening nation would be to create an empowered more effective international court of arbitration among and between nations, building on the embryonic early first international court. And as a secondary objective, the United States sought that Second Hague Conference to develop and advance rules of armed conflict. There was some delay in actually convening that meeting. It had to wait for the end of the Russo-Japanese War. And in the meantime, during that delay period, there was also the Boer War, waged in South Africa against British colonial rule. But eventually, and the formality is interesting, the inviting sovereign was the Tsar of Russia. Eventually, the Second Hague Conference convenes. June 15th, 1907 is the first formal session. 44 nations are represented, which by our standards sounds small until you remember that we're talking about an imperial world and only 47 countries that existed as of 1907. So 44 of 47 countries are present. And over that period from June of 1907 until October of 1907, these nations accomplish unanimous agreement in a structure that involved lots of subcommittee dialogue and then plenary session, deliberation and voting, and unanimous agreement on 13 resolutions, including many conceptual advances in developing more humane and restrained rules of conduct in war. That, you'll remember, was, from the United States perspective, the secondary objective. The primary objective was the international court, arbitration. And this Second Hague Conference achieved much less success in the realm of arbitration. It did not outlaw war, and it created no binding, independent international court process to step into international disputes and to adjudicate in advance grievances that might otherwise escalate into warfare. Instead, the nations simply reached in principle a discussion resolution that would be desirable as some later accomplishment. But that was not for want of trying. And trying is part of what I'm hoping to sketch here for you as we consider these points in time. It's important to note here and now, 100 years later, almost to the day, because this is a late August 1907 process that I'm about to describe, the leading role and the philosophy of the United States government at The Hague, at that second conference. The United States was, at that gathering, the neutral nation. It was not invested in or tainted by the interests and clashes of the continental European empires. The United States was, at that gathering, the proponent, from President Roosevelt's call for the conference, to the diplomats he sent, to the arguments they raised, to the drafts that they propounded, of a real, empowered international court of arbitration. The United States' vision explicitly was willing to, and publicly did, advocate sacrificing some sovereignty in the interest of international justice. The particulars are striking to consider, because this is the United States proposal for the new and binding court membership that it advocated. A tribunal of 15 judges. Now you might say, well, court packing, right? Here it comes. No. The 15 would be, on the United States proposal, comprised of 9 judges from Europe, 2 from Asia, and only 4 from the United States. In other words, we propose to be bound by a majority institution and tribunal comprised not of ourselves. We were not successful, the United States, but we were determined to continue this pursuit, including at a third Hague Conference and those thereafter. And it was agreed, as one of the subsidiary accomplishments of 1907, that these meetings would recur at regular 8-year intervals. In other words, we would next gather the nations of the world in 1915 to continue this process of development toward international law, which of course never happened, because by 1915, Europe was at war. The United States soon would join that war to end all wars. Much blood would be shed for very little purpose, and this conversation, 1899-1907, in a sense, becomes transformed. As of fall 1907, however, the Hague Conference, the second conference, had accomplished quite a bit. It had accomplished in global discourse visibility for these principles of law and justice. it had educated effectively across nations and peoples in the names of these concepts and ideas and objectives. And particularly, it had had something of a galvanic effect on some Americans, many Americans, I'd venture to guess, but let me just flag 4 for you. One was a professor and a budding New Jersey politician named Woodrow Wilson. Another was a young lawyer and a world traveler and a very close watcher of President Theodore Roosevelt. Indeed, he emulated him in many regards. His name was Frank Roosevelt. A third, locally in Frewsburg, just a few miles south of here, was a 15-year-old voracious newspaper reader and a rising high school junior, a very active interscholastic debater on policy issues, including, in the next couple of years, this very question, Robert Howitt Jackson. And a fourth, even more obscurely, in Missouri, was another young student whose talents and efforts would, in later years, carry him to war and business failure and machine politics and ultimately some greater success, Harry S. Truman. A third point in time, the interval that separates this pre-World War I Second Hague Conference moment from the late 1930s and the Nuremberg moment. I can't do more in this forum than simply note it is there, it is vast, it is significant. It includes, of course, the war. It includes, of course, the Allied victory. It includes the 14 points. It includes Paris. It includes the effort, failing though it was, to prosecute war criminals at Leipzig. It includes the Kellogg-Briand Pact in the 1920s and its declaration that war is now against the legal principles of nations. A fourth phase that follows on that is, of course, the brink of war. 1940 and 1941 is a particular moment I want you to think about. And focusing on 2 of those people and 2 particular moments, this is an echo of the Second Hague Conference that one can see visibly. The first is a deal between the United States and Great Britain, culminated in the late summer of 1940, to provide 50 overage American destroyers from the World War I era inventory to Great Britain, which by that fall stood alone against the Nazis and was being obliterated by U-boats on the Atlantic. In return, the United States, the trading party, got 99-year basing rights on British territorial properties throughout the North Atlantic and the Caribbean. The basis for destroyer deals of President, now Franklin D. Roosevelt, is a controversial, in the face of neutrality legislation, in the face of international criticism, involvement by a country that's deeply isolationist, and an involvement of questionable legality. The lawyer who works it, agonizes about it, advises against a first phase, causes it to be reconfigured, and then approves it in a fairly sophisticated legal opinion is the Attorney General of the United States, the 15-year-old debater, now in his 40s, Robert H. Jackson. That discussion during that summer is filled with the words, Der Haag. A second moment, also portrayed directly from Jackson's recollections and insights in his memoir, That Man, which I had the luck to discover and the privilege to publish, is a speech that Jackson gave in Havana to the International Bar of the Americas in March of 1941. Actually, he only wrote it. Rough seas prevented him from getting to Havana. So if you had hard travels, it once was tougher to get to places. But what Jackson explained in that speech, building on the destroyer deal and the Lend-Lease program that was now being legislated and other military production escalations that were occurring in the United States, was that the United States was legally entitled to do this because Germany's aggressive military moves in the European continent and against Britain were illegal under customary international law and treaty commitments. That aggression was illegal. And in that speech and in those discussions, which includes Roosevelt and Jackson, they talk going back to The Hague in 1907. A fifth moment is Nuremberg itself, 1945, 1946. And here others of many higher credentials than my own will do the primary discussing, so I want to just touch on a few points. One is that Robert Jackson, now a Supreme Court justice, gets this post-war job to prosecute Nazi war criminals directly from the new president, Harry Truman, executing a plan of the old president, the late Franklin D. Roosevelt. And it brings him into lots of War Department and State Department and other activity that he was not privy to. In the ramping up phase in May of 1945, one of the things, among many, many, that Jackson learns about is actually a Treasury proposal, become War Department plan, become San Francisco Conference proposal to use German people as repair labor forces both across the European continent and in the Soviet Union. The numbers being proposed by the United States government and Great Britain are north of 1 million Germans. Jackson gets wind of this, which is close to a done deal. This is a topic of Yalta and London and San Francisco and the vengeance and the injury of these Allied victors, and invokes the Hague Conference. He says, I will not do this job on behalf of governments that are about to embark on slave labor, when that is part of the conduct that is to be investigated and, if possible, prosecuted and adjudicated by the thing I've been asked to take on. It runs, and these are his exact words, directly in the face of the commitments that the nations of the world made at both Hague conferences and the subsequent treaty obligations impose on us. And the entire American government blinks, which causes this proposal largely to fall apart. A second aspect of Nuremberg occurs actually in London. There is a legal diplomatic negotiation process that Jackson has to do before he gets to Nuremberg. And what they are convening there among the four Allied powers, the United States, the Soviet Union, Great Britain, and France, is in some sense a descendant of the process that perhaps began in 1899, much more vigorously occurred in 1907, continued in Paris following World War I, and so forth. It is an international discussion of legal progress and shared principles. That produces the agreement and the charter that creates Nuremberg and the first International Criminal Tribunal. And that's the third thing I'd like to tick off just briefly. They then went to Nuremberg and did it. A fair, public trial before an independent tribunal. Perhaps based on a legal invention. Perhaps ex post facto in a former criminal law sense. In my view, more likely a legitimate criminal law development in the string of developments up to that point in time. But in either case, now, at the culmination of Nuremberg, a precedent going forward that henceforth the waging of aggressive war, the commission of war crimes, the perpetration of crimes against humanity, and common plan, agreement, and conspiracy to engage in any of and all of those is against the body of international law as a crime for which not only organizations but individuals up to the level of heads of state can be held accountable. But of course, what does that mean as Nuremberg culminates in the fall of 1946? Could the second half of the 20th century and later, our young century, redeem or begin the process of redeeming the war and the bloodshed that characterized the first part of the 20th century? And thus, phase 6, 1946 and onward, looking forward from Nuremberg. Let me first read a few of Jackson's eloquent words. This is from his October 7, 1946 report, home from Nuremberg after the one and only international trial, to Harry Truman, the man who sent him, reporting how he, Jackson, did the job as a predicate to formally resigning the responsibility. And this is Jackson's summary of what Nuremberg amounted to. The Nuremberg trial has put that handwriting on the wall for the oppressor as well as the oppressed to read. Of course, it would be extravagant to claim that agreements or trials of this character can make aggressive war or persecution of minorities impossible, just as it would be extravagant to claim that our federal laws make federal crimes impossible. But we cannot doubt that they strengthen the bulwarks of peace and tolerance. The four nations, through their prosecutors and through their representatives on the tribunal, have enunciated standards of conduct which bring new hope to men of goodwill, and from which future statesmen will not lightly depart. These standards by which the Germans have been condemned will become the condemnation of any nation that is faithless to them. By the agreement and this trial, we have put international law squarely on the side of peace as against aggressive warfare, and on the side of humanity as against persecution. In the present depressing world outlook, it is possible that the Nuremberg trial may constitute the most important moral advance to grow out of this war. The trial and decision by which the four nations have forfeited the lives of some of the most powerful political and military leaders of Germany because they have violated fundamental international law does more than anything in our time to give international law what Woodrow Wilson described as the kind of vitality it can only have if it is a real expression of our moral judgment. A fairly optimistic and high and perhaps self-congratulatory assessment of his own work. But of course, he is writing Truman and articulating this at a moment when the Cold War has begun, perhaps literally in the courtroom at Nuremberg, when a decision has been made by Great Britain and the United States on the direct recommendation of Jackson to attempt no more international trials, and when the prospect of a World War III is a real thing. That fall, Jackson wrestles privately with the question of what he should say, publicly and privately, about the United States government seeking the new United Nations to formally adopt the Nuremberg Principles, the Charter, and the judgment of the International Military Tribunal. It's captured, among other places, in an exchange that Jackson has privately with Walter Lippmann, the great American columnist, opinion shaper, a visitor to the Nuremberg trial earlier that year. On November 16, 1946, Jackson writes to Lippmann, privately, a note of caution, as Jackson describes it. I am fearful that in the present temper of things, more ground may be lost than gained by going to the United Nations for a vote, the United Nations, which has been structured to give the Soviets a Security Council veto. I hope my fears are ungrounded. In December of 1946, the United States does participate, and the Soviets do participate, in a UN adoption of the Nuremberg judgment, and to that extent, the international community ratifies Nuremberg. But the Cold War also is continuing. And the next place that Jackson describes this, that I'll briefly describe, is right here, at Chautauqua Institution, in the amphitheater just up the hill from us, on the 4th of July, 1947. What Jackson articulates there is two things, somewhat in tension: an awareness of the international situation and a caution. Nuremberg is progress. International disputes and the challenge of coexistence are even bigger now in a nuclear age and in a US-Soviet bipolarity. But one can still be hopeful. And one who has worked in the realm of diplomacy, projects, and international law with that adversary, as I, Robert Jackson, have, he told the Chautauqua audience on that 4th of July, can have hope that a World War III with the Soviets is not inevitable, and that Nuremberg and the Hague Conventions and the UN Charter and other advances in international law, which are known to and appreciated by those Soviet leaders, and this is Jackson, who had dealt with Wyszynski, who had dealt with Nikitchenko, who had dealt with Molotov, are things that we share. A third after Nuremberg moment where Jackson speaks to this, and this draws on the international character of the continuing discussion, is in Banff on September 1, 1949, to the Canadian Bar Association. Jackson says there, in that time of high international tension and international paralysis, that Nuremberg, in appreciation of what we already have in the bank from Nuremberg, is now needed more than ever, because the machinery, 1949, to make new international law is so inadequate, inertia is so great, conflict and suspicion today are so paralyzing, that we can foresee no time when aggressive wars will be outlawed or their perpetrators legally punished if the Nuremberg basis for doing so was not valid. Finally, within a year of the end of his life, November 1953, Robert Jackson speaks to this meaning and legacy and force of Nuremberg in Chicago. The date is November 2, 1953. He's giving a speech dedicating the American Bar Association Center, a newly constructed, majestic, bold legal process spearheaded by the executive director of the ABA at the time, Whitney R. Harris, who's here with us. And in Chicago, this is, I think, a closing word from Jackson's perspective. The basic ideas of just dealing and civilized living are so strikingly alike among lawyers that we may foresee a mutual understanding and cooperation between the professions of the Western world greater than has existed in the past. And if a peaceful and stable international order is ever reached, it is not rash to predict that it will result from acceptance by the legal professions of all nations of an international rule of law as a curb on lawless power in control of great states. In other words, lawyers, international lawyers, have what Nuremberg put in the bank, share it in their levels of understanding, pursue it in their projects, and embody it in their personal commitments. And that's, of course, where we are today. That's who sits before me and with all of us, and who we will be hearing wonderful dialogues from. The significance of the international prosecutors who are here from 1945 and forward is that they carry on the Nuremberg process, which is the Hague Project, which is humanity's project. They sought in the past, and they seek today, accountability and fairness and world building and deterrence. And Nuremberg is young. Thank you very much.
Wow. Thank you so much, John. It's always a pleasure to hear you and hear your historical insights, because in fact we do have the weight of history upon us today, and we can feel its currents swirling about us, not just past but present but also future. Well, as I hail from obscure Missouri, I guess it falls to me to take the podium now. I'm Layla Sadat, director of the Whitney R. Harris Institute for Global Legal Studies at the Washington University School of Law, and I have the distinction, I suppose, to be the only member of my sex here, which is an advancement over the 1907 Hague Peace Conference, at which no women were present. But it is obviously an extraordinary burden upon me, because I have to carry the weight of half of humanity here today. Not to mention the extraordinarily distinguished resumes of everybody who is here. First, I would like to say thank you so much to Greg Peterson and the Robert H. Jackson Center for putting this together. As usual, it's a stunning affair, and I'm honored to be here. The American Society of International Law, Betsy Anderson and Rick LaRue are here, and thank you so much to ASIL, the Chautauqua Institution, the Planethood Foundation, and of course David Crane, and especially Syracuse University College of Law for putting together this extraordinarily important event. Well, the city of St. Louis in obscure Missouri has a particular connection, and very special connection, to the 1907 Hague Peace Conference, because it was at St. Louis in 1904 at the holding of the St. Louis World's Fair, which was perhaps the last major event to be held in St. Louis, but nonetheless it was extraordinarily important. The Interparliamentary Union meeting in 1904 in the city of St. Louis issued the call to President Theodore Roosevelt to convene a second Hague Peace Conference. And indeed, St. Louis has many connections, in fact, a living embodiment that I'm going to introduce in a moment, to the 1907 Hague Rules and their subsequent history. First, it is my honor to introduce Whitney R. Harris, and I am somewhat humbled to do so. I first met Whitney when I was a young law professor in probably my second year of teaching, and I was asked to introduce Sharif Bassiouni, who couldn't be here today, at the American Jewish Congress event that was held in St. Louis in, I think, 1994, to discuss what was going on in Bosnia. And Whitney Harris and Sharif Bassiouni and I sat on the podium together, and I was extraordinarily nervous because I was in my second year of teaching, and Whitney was so extraordinarily gracious to me on that occasion, as was Sharif, and both men pointed out that on the podium, on the dais, were 3 generations of individuals committed to the cause of international criminal justice. And I might add to the 3 generations that were there that day, we also have many generations. I have my own children now, so we have a 4th generation and even children unborn who are very much dependent upon the work that Whitney and others and Henry King started at Nuremberg and upon who we rest today. Whitney Harris was born, I hope I'm not giving too many secrets, Whitney, but Whitney Harris was born a few years after the 1907 Hague Peace Conference that was held. He was born in Seattle, Washington. He attended the University of Washington. He attended law school at the University of California. He graduated both with distinction, I should add. He then practiced law and entered the United States Navy shortly after the Japanese attack on Pearl Harbor. He served as a line officer in the Navy when he retired with the rank of captain in the JAG Corps. Toward the end of World War II, and this is where he joins our primary hero that John has elucidated, Whitney Harris, by then Lieutenant Harris, was assigned by the Navy for special duty with the Office of Strategic Services and was placed in charge of the investigation of war crimes in the European theater. Lieutenant Harris joined the staff of Supreme Court Justice Robert H. Jackson in the trial of the major German war criminals at Nuremberg, Germany. He served as a prosecutor throughout the trial until October 1st, 1946, and was primarily responsible for the prosecution of Ernst Kaltenbrunner, the Gestapo, and the SD. For his work at Nuremberg, he was awarded the Legion of Merit. Since then, he has been the dean of a major United States law school. He has served the bar ably with his service as a lawyer. He has become a well-known and generous benefactor in St. Louis for the arts, for cultural institutions. In fact, this is an individual who has dedicated his long, and I hope much longer life, to the international rule of law. And without further ado, ladies and gentlemen, I give you Whitney R. Harris. Thank you.
I'm not quite as nimble as I used to be. Thank you, Layla, for that extravagant introduction. Not deserved at all. In all of history, the 20th century, and especially its first half, witnessed the gravest inhumanities and killings that man has ever perpetrated upon man. It is hard to believe that the long road toward civilization which man has trod since the dawn of history could have led to the dreadful conflicts of World War I from 1914 to 1918 and of World War II from 1939 to 1945. The tragedies of these wars past, from the battlefields of Verdun, where thousands of soldiers died in miserable, muddy trenches under unremitting rifle and cannon fire, to Hiroshima and Nagasaki, where hundreds of thousands of civilians were pulverized by atomic bombs. There must be an end to war, or there will be an end to civilization. The Nuremberg trial of 1945-46 was man's first effort to subject tyranny and war to the rule of law. On the first day of October 1946, The 8 judges constituting the International Military Tribunal took their seats at the bench in the courtroom of the Palace of Justice in Nuremberg, Germany, where during the preceding 10 months, the major German war criminals had been tried for committing wars of aggression, war crimes, and crimes against humanity during the Second Great War of the 20th century. The judges faced the prisoner's dock, which was empty. Before it, the defense counsel occupied their chairs. To the left were the prosecution tables occupied by the 4 allied prosecutors and their staffs. I sat at the American table. Behind us, the visitors' gallery was packed with members of the press and visitors. The defendants were to be brought into the courtroom one at a time to hear the sentences pronounced against them. At 10 minutes before 3, the panel door in the back of the prisoner's dock slid silently open. The defendant, Hermann Goering, stepped out of the elevator which had brought him from the ground floor where the other defendants waited. Goering put on a set of headphones which had been handed to him by one of the white-helmeted American guards. The president of the tribunal began to speak. Goering signaled that he was unable to hear through the headphones, and there was an awkward delay while the technician sought to correct the difficulty. A new set of headphones was produced, and once again Goering quietly awaited the words which were to decide his fate. Defendant Hermann Wilhelm Goering, on the counts of the indictment on which you have been convicted, the International Military Tribunal sentences you to death by hanging. The number 2 Nazi turned on his heel and passed through the paneled door into the waiting elevator. The door closed, and there was a hum of whispered voices in the courtroom as those present awaited the arrival of the next defendant, Hess. Rudolf Hess, who had flown his Messerschmitt to England in a futile effort to persuade the British to abandon the fight with Germany, was sentenced to imprisonment for life. The other defendants appeared in turn and received their sentences. 12, including Martin Bormann, who had been tried in absentia, and my defendant, Ernst Kaltenbrunner, received death sentences. 3 were acquitted, and the remaining 7 received varying terms of imprisonment. The tribunal declared as criminal organizations the leadership corps of the Nazi Party, the Gestapo and SD, and the SS. Appeals were taken by all of the defendants to the Allied Control Council except Kaltenbrunner. The appeals were uniformly denied at a meeting of the Council on October 18. I had been designated by United States Chief of Counsel Justice Jackson as his personal representative at the executions and was present in the Palace of Justice on the fateful night of October 15, 16, 1946. Shortly before midnight, the electrifying word was released that Goering had cheated the hangman by taking poison while lying ostensibly asleep upon the bed in his cell. Death thus came to Goering by his own hand, as it had come to Hitler, Himmler, and Goebbels before him, even as the prison officer was walking to the cell block to give formal notice of the executions to take place that night. At 11 minutes past 1 o'clock in the morning of October 16, the white-faced former Foreign Minister Joachim von Ribbentrop stepped through the door into the execution chamber and faced the gallows on which he and the others condemned to die by the tribunal were to be hanged. His hands were unmanacled and bound behind him with a leather thong. Ribbentrop walked to the foot of the 13 steps leading to the gallows platform. He was asked to state his name and answered, Joachim von Ribbentrop. Flanked by 2 guards and followed by the chaplain, he slowly mounted the stairs. On the platform, he saw the hangman with a noose of 13 coils and the hangman's assistant with a black hood. Asked to state any last words, he said, "God protect Germany. God have mercy on my soul. My last wish is that German unity be maintained, that understanding between East and West be realized, and there be peace for the world." The trap was sprung, and Ribbentrop died at 1:29. In the same way, each of the remaining defendants approached the scaffold and met the fate of common criminals. All, except the wordy Nazi philosopher Rosenberg, uttered final statements. After the executions, the body of each man was placed upon a simple wooden coffin. A tag with the name of the deceased was pinned to coat, shirt, or sweater. With the hangman's noose still about the neck, each hanged man was photographed. The body of Hermann Goering was brought in and placed upon its box to be photographed with the others. In the early morning hours, 2 trucks carrying the 11 caskets left the prison compound of the Palace of Justice bound for the crematory at Dachau concentration camp near Munich. There, during all of that day, the bodies were cremated. It was reported that the urns containing the ashes were taken away to be emptied into the river Isar. The dust of the dead was carried along the currents of the stream to the Danube, and thence to the sea. The defendants who had received sentences of imprisonment were transferred to Potsdam prison, which had been designed for some 600 prisoners, but was now reserved for the 7 from Nuremberg. As the years passed, the defendants completed their terms and were released. The last prisoner was Rudolf Hess, who had been sentenced for life. On August 17, 1987, 41 years after the final judgment of the tribunal, Hess managed somehow to commit suicide. With his death, the Hitler tyranny ended. The tyrant and his chief cohorts were gone. They had sought to achieve greatness in history, but they inscribed their names in sand, and clean waters fell upon the beach and washed them out. They had intended to establish a new order for Europe, but they built upon pillars of hate, and what they stood for could not stand. Hitler and his Confederates, who led Germany to disaster in the 20th century, are all dead. They were the principal actors in a fearsome drama, but as Prospero foretold, they were all spirits and melted into air, into thin air. The tyrant Hitler and his associates in crime will someday be forgotten. Forgotten, too, may be their crimes. It is enough that tomorrow's world remembers what today's world has learned through the bitter experience of this fallen regime, that tyranny leads to inhumanity, and inhumanity to oblivion. The legacy of the trial of the major German war criminals before the International Military Tribunal at Nuremberg is a law-ordered world in which nations live at peace. It is not the fault of the tribunal or its judgment that this legacy has yet to be fully accepted in the world. If Nuremberg had not occurred and the anger of the Allies had been assuaged by the executions of alleged war criminals without trial, we would not have advanced an iota toward a peaceful world. It is a legacy of Nuremberg that war crimes, crimes against humanity committed in war and aggressive war itself shall never again be tolerated in a peaceful world in which all disputes among nations are resolved under the rule of law. The world in which we live is subject to the overwhelming fact of force. Nature speaks to us in that idiom, the hurricane that rises from the sea and spreads havoc on the land, the earthquake that shatters the stillness of the day and brings buildings tumbling to the ground, the erupting volcano that sends boiling lava over green fields and quiet homes, are forces which nature may unleash in angry mood. Against these forces, man has yet to prove his greater power. No mortal has shown the way to still the voice of the mighty hurricane or quell the mysterious shifts of subterranean mountains or stop the red lava in its flow to the sea. And yet, these forces of destruction, dominant though they may be, have not the threat to humankind which man himself has devised. The atomic age burst in fury upon the world. We are caught in the peril of that age. Man-made forces can now destroy man. Perhaps civilization is in its decline and barbarism its due. Rudolf Hirsch, the commandant of Auschwitz concentration camp, confessed to me at Nuremberg, "I commanded Auschwitz until December 1943 and estimate that at least 2.5 million victims were executed and exterminated there by gassing and shooting and burning." After hearing this confession, the defendant Hans Frank, the Governor General of occupied Poland, declared, "That was the low point of the entire trial. To hear a man say out of his own mouth that he exterminated 2.5 million people in cold blood, that is something people will talk about for 1,000 years." The spirit of Hitlerism was one of the greatest factors for evil in history, for Hitler had the incomparable advantage over tyrants of earlier times of modern technology through which his propaganda could be constantly pounded into the German people and his war machine could be made to strike his enemies with shattering force. The consequence of that spirit was a commitment of crimes against humanity which stagger comprehension. The people of Europe and America became aware that the Hitler regime had committed acts of great wickedness, but not until these crimes had been exposed to the searching light of truth in an open judicial forum did the world gain comprehension of their enormity. The Nuremberg trial marked the close of the Hitler era, but it did not mark the end of the struggle for peace. The case of tyranny versus justice has been pending in the courts of mankind since the dawn of history. The issue is whether humanity shall realize its right to freedom or whether mankind shall forever suffer the lash of autocratic power. Nuremberg gave meaning to the rule of law in international relations. If its principles were to gain universalism, a permanent international judicial forum had to be established in which future cases involving war crimes, crimes against humanity in war, and the waging of aggressive war had to be resolved without resort to military force. The General Assembly considered the proposal for an international criminal court when drafting the Convention for the Prevention and Punishment of the Crime of Genocide, but failed to approve it. On the day it adopted the Genocide Convention, December 18, 1948, however, the General Assembly requested the International Law Commission to undertake a study of a permanent international criminal court. Thus began a long period of international negotiations culminating in a General Assembly resolution of December 16, 1996, calling for a diplomatic conference of plenipotentiaries to meet in 1998. The conference convened in Rome on June 15, 1998. Deliberations concluded on the following July 17 with the adoption of the statute for an international criminal court by a vote of 120 in favor to 7 against, with 21 abstentions. Voting against the statute were Iraq, Libya, Qatar, Yemen, China, Israel, and the United States of America. The Arab countries opposed the statute primarily because it omitted the death penalty. China was concerned with the possibility of charges of offenses against human rights. Israel believed that the shifting of population into occupied territory should not have been included as a war crime. The United States feared that its role as primary peacekeeper with American military forces deployed around the world might be adversely affected by spurious charges of war crimes. But the overwhelming majority of the nations represented at the Rome Conference endorsed the statute as constituting the primary international document for peace and justice in the latter half of the 20th century. It is fitting that it should have been adopted in Rome, for as Virgil observed in the Aeneid so long ago, the Greek-shaped bronze statues so real they seem to breathe, and carve cold marble until it almost comes to life. The Greeks compose great orations and measure the heavens so well they can predict the rising of the stars. But you, Romans, remember your great arts, to govern the peoples with authority, to establish peace under the rule of law, to conquer the mighty and show them mercy once they are conquered. The Rome Statute is a treaty document establishing for the first time in world history an international criminal court complementary to national criminal law jurisdictions capable of bringing to justice persons guilty of aggressive war, yet to be defined, war crimes and crimes against humanity, including genocide. It recognizes that crimes occur in the world which require the availability of an international judicial forum for trial and punishment. The statute was the product of the efforts of many persons, beginning with the drafting of the Charter of the International Military Tribunal more than half a century before the conference. But 50 years is just an hour in mankind's struggle for justice. Revision of the Rome Treaty must be considered after 7 years of trial with its law and procedures. 700 years may pass before mankind is able to eliminate war in the world and establish a system of universal justice. Law is the means to justice. The first worldwide conflict led to the conviction that civilization can no longer tolerate war as a method of settling international disputes. The Second World War turned that conviction into law. Aggressive war has long been morally condemned. It has now become the foremost crime against humanity. How does it end, this time of man on earth? Will it be by a flood of the seas over the land, the return of the monster Tyrannosaurus Rex, the crash of a comet into the earth? None of these. The forces of nature we shall surmount. We have not to fear save ourselves, only ourselves. The tyrant must be forced to end his tyranny. The aggressor must be punished for his aggressions. And law, not force, must rule the world. man's destiny lies in the hands of man. Thank you. Thank you very much.